Thank you, Madam Deputy President. I also rise to speak to the Crimes Amendment Sexual Offences and Female Genital Mutilation Bill, and I speak on behalf of the opposition and note that the opposition is happy to support this bill. It's part of the important and regular updating of our criminal law to ensure that it remains fit for purpose. And it is a wonderful example of the relationship between common law and the legislation made by this Parliament, responding as it does to 4 issues raised by recent cases and inquests. In Russell and the Crown, there was an appeal by an extreme body modification artist who had performed a cosmetic procedure on a 29-year-old woman. The artist successfully appealed a conviction of female genital mutilation, arguing that the law was restricted to protecting children. The amendments introduced by this bill clarify that female genital mutilation covers adult victims as well, not just children. It also makes clear that the conduct covered by the prohibition is not restricted to acts for ritualistic or traditional purposes. The amendment also introduces exception for piercing or tattooing, which raises the important definitional issue of exactly what is covered by the offence in Section 45 of the Crimes Act. There is no longer any bright line distinction between surgical and cosmetic procedures, and it will be interesting to see how the courts interpret the new piercing exception in the light of the Section 45(1)(a) prohibition. Perhaps the line we are reaching for is that any mutilations which would prevent a person from experiencing sexual pleasure or would diminish the pleasure they would normally be able to experience should be prohibited, but any measures done to provide pleasure to the woman herself, whether cosmetic or actual, should be permitted. But even this distinction has complexities, as much sexual reassignment surgery, currently permitted by Section 45(3)(c), also has the consequence of removing or diminishing the possibility for sexual pleasure. None of these issues were addressed in the second reading speech, despite the fact that they have been raised by the inclusion of the new tattooing and piercing exception. We recognise that these are difficult issues to resolve, but anticipate that they are likely to arise. It is important for very clear thinking around these issues. The Law Society of New South Wales has expressed concern about criminal regulation of female genital mutilation, not because they endorse the practice, but because they recognise the complexity reflected in the current amendments of intersecting health, cultural, social and criminal justice factors. Their position is that the practice of female genital mutilation may be more effectively addressed through the implementation of culturally appropriate education and community outreach approaches than reliance on criminalisation alone. Their call for community outreach should be heeded and appropriately resourced. This bill also addresses the decision in DPP and Presnell, in which the Court of Criminal Appeal held that the offences in Part 3, Division 10, Subdivision 7 of the Crimes Act require intention, so that if the presence of a child was a sexual stimulus, but the sexual actions were hidden from the child, this would not constitute an offence. These amendments will capture the circumstances where the presence of a child is being used for sexual gratification, even if there is no intention to engage the child physically. This is the most appropriate amendment. The third amendment responds to the decision in the coronial inquest into the deaths of Cindy and Mona Smith. This decision highlighted a lacuna in the criminal law, whereby an offender can escape liability if it is inconclusive whether a sexual act was committed while the victim was alive or was committed after death. This bill will address that gap. It will enable a trier of fact to return a special verdict in these circumstances and aligns with the special verdict provisions in Section 121 of the Act. We're very happy to support this change. No perpetrator should escape conviction for sexual abuse because there is doubt about whether his victim was alive or dead at the time. The fourth change in the bill aligns New South Wales law with the National Classification Code and lifts the age threshold for the definition of a child from 16 to 18 years of age for the purposes of child abuse material offences. We're very happy to support this change, which closes a loophole whereby creating vile images of children may not be an offence if the subject appears to be 17. These are all sensible changes which will increase community safety. Accordingly, the opposition is happy to support this bill. But we call on the government to do more than simply pass this law. We need the government to ensure that these laws are properly enforced and resourced, Only then will our society truly be safer for women and children.